Yeah, I believe you have that. Sure. We got all the discovery here.
We on the record in cause number 325-314. The case is style of state of Texas versus Eric Dwayne Richard. Mr. Richard, would you please raise your right hand? Mr. Richard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Richard, you may put your hand down. How you doing, Mr. Richard? You doing good? That's good. Now, Mr. Richard, you're represented here by your attorney, Mr. Bruce Cobb. Mr. Cobb, how are you doing?
I'm doing fine.
That's good. Mr. Richard, the information in this case alleges that on or about September 9th of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Richard, do you understand what you've been charged with? And to discharge, Mr. Richard, how do you plead? Guilty, not guilty, or no contest? Now, you're pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? You have to speak up. She's taking a record.
Yes, sir.
Now, Mr. Richard, I have before me a document that is titled the misdemeanor plea admonishment. Now, I've checked the box up here that say that this is a Class A misdemeanor, and a range of punishment for a Class A misdemeanor: confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000, or both such fine and confinement. Do you understand your range of punishment?
That they see 1 year.
I'm saying that's the range of punishment. Your punishment can go anywhere within that range. Do you understand that? Now, do you recognize this document? Okay, on page 2 of the same document, Mr. Richard, there are a set of initials, ER, next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document? And on the next page of the same document, Mr. Richard, there's a signature above the line that's titled defendant. Is that your signature? You have to speak up.
Yes, sir.
And on the next document, which is titled the trial court certification of defendant's right of appeal, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that? I also have before me a document that is titled the discovery certification. Do you recognize this document? You have to speak up.
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes, sir.
Mr. Richard, these documents that I've just mentioned to you, did your attorney go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Any objections?
No objection. Your Honor.
And State, will you also be offering State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections?
No objection.
Okay, no objections. State's Exhibits 1 and 2 are admitted. Mr. Cobb, you've advised in counsel, Mr. Richard, is there any evidence that he is currently mentally incompetent to stand trial?
None whatsoever.
Mr. Richard, your attorney, Mr. Cobb, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Richard, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
It's 180 days jail. That's probated for 15 months. $1,000 fine, 80 hours community service, a DWI education course, drug and alcohol assessment, and ignition interlock.
Okay. Mr. Richard, the state is offering that you serve 180 days in the Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you will be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $1,000 plus court costs of $407, which comes to a total of $1,407. That's the total of fine and court costs of $1,407. You'll be required to pay $60 probation fees each month, $15 urinalysis fee each month. You will be also required to pay a Jefferson County DWI education class and initial evaluation fee of $125. And should a further evaluation be needed, you will be required to pay $50, additional $50. Now, your total monthly installments for this case, and you will also be required to reimburse the court-appointed attorney's fees of $250. Now, your total monthly installments for this case will be $195 a month. Mr. Richard, would you be able to pay the $195 each month? You will? You will be required to perform 80 hours of community service, attend a DWI education class, and have a drug and alcohol assessment, and you'll be required to install a DWI interlock device on any vehicle that you own or operate. And you also be required to adhere to the other standard terms and conditions of probation. Mr. Richard, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Okay. Mr. Richard, I will follow the plea bargain agreement that you have entered into with the state. Mr. Richard, you're going to stand on the X and follow the directions of our clerk. And once you finish following those directions, you'll be free to go, and you have a blessed day.
Mr. Richard? All right, you can get your right thumbprint on that blue light. Thank you. And Mr. Richard, if I could get your signature on that signature pad, you won't be able to see it, but I will. Okay. And then Mr. Cobb, if I could get your signature as well. And Mr. Richard, raise your right hand. Do you swear that you've never before been convicted or given deferred adjudication or regular probation for a felony or misdemeanor in this or any other state? Okay. And you have no pending charges that you're aware of? Okay. You're going to report to this address whenever you leave here.
We're on the record in cause number 322600. The case is styled the state of Texas versus Emily C. Cook. See, affidavit, when did you see?
Most recent one?
Yeah. Yeah, the most recent one. We're on the record in cause number 322600. The case is styled the state of Texas versus Emily C. Cook. Your full name is Emily C. Cook, is that correct?
Yes, Your Honor.
How you doing, Ms. Cook?
I'm good. How are you?
I'm doing fine, Ms. Cook. You're here with your attorney, Mr. Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
That's good. Mr. Lawrence, well, Ms. Cook, I have before me a motion to revoke your probation. And previously, we were on the record in this case. And this motion was read by the State Assistant District Attorney, Ms. Julie Maxey. And the court went over the allegations in the motion to revoke. The state abandoned, there are 7 allegations in this motion to revoke. The state abandoned allegations 1 and 7. And Ms. Cook, you pled true to allegations 2, 3, 4, and 6. Is that correct?
Yes, Your Honor.
And you pled not true to allegation 5. Is that correct?
Yes, Your Honor.
For the record. Now, well, let me do this here, Ms. Cook. Did I swear you in?
No.
Let me do this here, Ms. Cook. Would you please raise your right hand, Ms. Cook? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
You may put your hand down. Now, Ms. Cook, again, the court, we had initially a contested hearing that was set. The state read the motion to revoke your probation in cause number 322600. And at the end of reading the motions, the court, was informed by the district attorney's office that they were abandoning allegations 1 and 7. And you pled true to allegations 2, 3, 4, and 6. Is that correct?
Yes, Your Honor.
And you pled not true to allegation 5. Is that correct?
Yes, Your Honor.
Now, and the court asked you, did you plead to those allegations freely and voluntarily? You remember that?
Yes.
And you informed the court that you did plead those allegations freely and voluntarily, and that you, one, understood what the allegations were. Is that correct?
Yes, Your Honor.
And you pled true to those allegations because they were true. Is that correct?
Yes, Your Honor.
All right. Now, I have before me, now since then, you and your attorney have been able to work out a plea bargaining agreement with the state. Is that correct?
Yes, Your Honor.
Now, I have before me the misdemeanor plea admonishments that was signed. Ms. Cook, do you recognize this document?
Yes, Your Honor.
The misdemeanor plea admonishment states exhibit number 1. And here, Ms. Cook, on page 2 of this document, they have a set of initials on a line next to a box that's checked MTRP, which means motion to revoke probation, true to allegations 2, 3, 4, and 6. Ms. Cook, are these did you place your initials on this document?
Yes, Your Honor.
And on page 3 of the same document, Ms. Cook, is that your signature above the line that says defendant?
Yes, Your Honor.
And on the next document, Ms. Cook, there's a signature at the bottom of this document. This document is titled Trial Court Certification of Defendant's Right of Appeal. The signature is above the line that's titled defendant. Is that your signature?
Yes, Your Honor.
There are 2 boxes that's checked at the top of this document. First box states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
The second box states that you are waiving or giving up your right to an appeal. Do you understand that?
Yes, Your Honor.
Now, Ms. Cook, prior to signing and initialing these documents, did your attorney, Mr. Lawrence, go over these documents with you? And did you read and understand everything in these documents?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
State, I have before me states exhibit number 1, State, you like to offer States 1?
Yes, Your Honor.
Any objections?
None, Your Honor.
No objection. States Exhibit number 1 will be admitted. Mr. Lawrence, you've advised and counseled Ms. Cook. Is there any evidence that she's currently mentally incompetent to stand trial?
Absolutely not.
Ms. Cook, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Okay, Ms. Cook, I will accept your plea of true to allegations 2, 3, 4, and 6. I will also find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your probation, and your probation is hereby revoked. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
It's for 40 days county jail, which is to begin on July 5th, 2021 at 2 p.m.
They always start at 6, I think. If I'm not mistaken. I think it's always at 6.
Oh, 6 p.m.
You want to make it 6, so she
Yeah,
doesn't have
yeah.
to get there till 6 p.m.
Yeah, it's usually at 6. If you can't be after 6, it's usually at
So
about
get there
6
at
p.m.
5:30 or something.
Okay,
I'll retype it.
okay. Now, Miss. Let me do this here, the 6. Any particular reason why it's starting on the 5th?
She has to get her affairs in order, Your Honor.
Okay,
I have a week to do that, so I'll just get my storage paid and get everything in order.
okay.
3 weeks.
And the reason why I was asking because, the 5th is after, the 4th. We have
We could do it before that.
huh?
I mean, we could do it before that.
Yeah,
So
yeah,
at least a few.
She has to put her little sister that
at
she's
least like
raising
5
right
days.
now.
Huh?
I said at least maybe like 5 days.
5 days?
Today,
Okay.
today.
And the reason why I was saying because it's the, holidays, we have a DWI case.
Yeah.
People do a lot of drinking on, holidays and so we don't want to, have none
Or
of that.
the second, is that a thing? That's a week.
Second or the third?
Yeah, the third's on a Saturday, the second's on a Friday.
Do they accept them on any day of the week?
There's less people there on Saturday. There's less staff there on Saturday.
Okay, so we'll go with the second. Okay. Yeah, we'll change that to the second. Okay, now,
So July 2nd, Your Honor.
That's it.
At 6.
July 2nd at about 5:30.
well, yeah, okay, so let me do this. Ms. Cook, now the state is offering that you serve 40 days in the Jefferson County Jail. You'll be given credit for any time that you're entitled to get by law. I don't know what that credit is. The jail will calculate that time. Now, in this case, Ms. Cook, there's also court costs of $67. Are you able to pay the $67?
Yeah.
You sure?
Yes.
I mean,
Today?
hmm?
Today?
No, I mean, you don't have to pay it today.
Oh, okay.
It's,
Yes.
you will be able to pay it.
Yes.
Okay,
She can't pay it by check, Your Honor. There's only like $15 in her account right now. So I don't,
I could get it before, it's fine. Before I go into 67.
let me do this here. I'm gonna look at your, I don't have nothing on here. Let's say you was making, I was looking at your affidavit of indigency that you filed. That was when you got your court appointed attorney.
Yeah.
Apparently you talked to someone, they filled in that you made like 300 weekly.
Yeah, I make about like 13 to 14 an hour, probably like 20.
Now, they didn't put any,
that's with tips included.
insufficient, and the Judge Pash noted that you had insufficient income. When the appointment, when you say that you met the the eligibility requirements for the appointment of a court-appointed attorney. So let me ask my question again. Have your income and improved, or is still the same?
Yeah, that's still the same.
Have your expenses changed any? That has it increased, decreased? Because you don't have any expenses on here. Let me do this here.
Not
So for
necessarily,
the-
really just a smart start.
So for the interlock device, which is Smart Start, has already cost her about $1,150, and they still haven't finished the job. And they've created a problem with who she pays.
Yeah,
her
but I
car
mean,
off with.
yeah, I know, but I'm just saying right now, her time, it'll be, I mean, she's getting jail time. I mean, it's conviction, so she no longer is on probation. She getting jail time in terms of her sentence. Okay. So my question is, if it's still the same, will you be able to pay the court costs, or will you not be able to pay the court costs?
I'll pay the court.
You can pay it.
I'll pay. Mhm.
Okay. Now, Ms. Cook, the state is offering that you serve 40 days in Jefferson County Jail. You'll be given credit for any time that you're entitled to get by law, and you'll be required to pay the $67 in court costs. Now, Ms. Cook, and this sentence will start on July 2nd of 2021, and I'll say at or before 6 p.m. Now, Ms. Cook, do you understand the state's offer?
Yes, Your Honor.
You think that the state's offer in your case is fair and just?
Yes, Your Honor.
Okay. And do you accept the state's offer?
Yes, Your Honor.
Okay. Well, bless you. And so the court will follow the plea bargain agreement that you've entered into with the state. Stand on the X next to your attorney. And once you finish here in court with your case, then you'll be free to go, and you have a blessed day. And Mr. Lawrence, this will conclude this is the only case you have today, so you'll be free to go as well, and you have a blessed day.
Thank you, Your Honor.
Okay.
If there were 5 p.m., because if you get there later than that, they may not get you signed in.
Okay.
They have to stand in line. You still gotta take your
We're on the record in cause number 326450. The case is styled the state of Texas versus Leslie Bertrand. We have Ms. Leslie Bertrand. Ms. Bertrand, would you please raise your right hand? Ms. Bertrand, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How you doing, Ms. Bertrand?
Good.
That's good. Now, Ms. Bertrand, you're here represented by your attorney, Mr. Willard Hall. Mr. Hall, how you doing?
You're great, Your Honor.
That's good. Now, we have present representing the state, Mr. Daniel Boyd, and we have Ms. Ashley Barlow, who is here with the Jefferson County Probation Office. Okay, Mr. Boyd, how you doing?
Good, Your Honor, how are you today?
I'm doing fine. Mr. Barlow, how you doing?
I'm good.
That's good. Now, Mr. Hall, you have filed this motion requesting a removal of an interlock device. In essence, I guess you're requesting the court to modify the conditions, at least this condition that's in her probation. Is that correct?
Yes, sir, Your Honor. Ms. Bertrand has served half of her probationary period. I believe she's been an ideal probationer. There have been no violations. She does work, and she has had difficulty with this interlock device. This particular one is the Draeger interlock device. The nearest place they service this is in Houston, Texas. And they do have a gentleman who comes over here to Beaumont once a month, am I right about that?
Yes, sir.
To work on it, but it's broken, so she's had to have it repaired. How many times have you been over there to have it repaired?
I went to Houston once and to the place in Beaumont. Like, I go once a month, supposed to be, and it broke 2 or 3 times back to back, and he did meet me in Beaumont, but it's been giving a lot of problems, and I had to have it. They put 2 brand new ones in the car. Like, I'm on my second, well, it'll be the 3rd one.
So
They replaced it.
but anyway, she's had to take off work a day to take care of this during the week. And this has caused a disruption with her employer, and the employer has warned her not to miss any more work. So we've got a conflict between her obligation to work in suitable employment as far as possible, and the other obligation is to have an interlock device inside of her car. Now, she is a single mother. She's got a teenage daughter, and she cannot afford to miss work. She has to work. And so we're asking, because she has served 50% of her probationary period, and there have been no violations, she's been an ideal probationer. We're asking the court's consideration of this, so she can remove the interlock device.
Okay, state.
Your Honor, the state would not be in agreement only in principle only. It would just defer to the court for the decision based off of the testimony of the probation department.
Okay, Ms. Barlow, would you please raise your right hand? Ms. Barlow, do you swear affirm, tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You may put your hand down. Mr. Boyd, you have questions?
Ms. Barlow, has Ms. Bertrand complied with all the terms of her probation?
Yes, as reviewing her records, she's been in compliance since she's been on probation.
And has she paid all her fines and fees, all that?
As of today, she's ahead on her fees.
No further questions, Your Honor.
And by the way, Ms. Bertrand, everything I've said, is that all that, your testimony that you would give?
Yes, sir. Just, it's been breaking a lot and causing extra problems.
Okay. Let me ask you this, I mean, is that the only brand of, what is called, the interlock? You said it was a Drago or something?
Draeger.
Draeger?
It's made in Germany. They're supposed to be very good. I don't know why this model is breaking. They do have other brands, but it costs a lot of money.
I had to pay the installation fee, and I pay them every month.
Understand?
So I just didn't want to have to do that again.
Okay, but
I think if she has been an ideal probationer under law, she can be eligible to get it off in half the time she served that.
Well, I think the law states that at the onset, the court, when the court orders an interlock, that the interlock cannot be less than 50% of the length of probation. That's what it says. It does not say that a person is eligible to get it off after serving half the time.
Yes.
Okay, so I mean, at the onset, if the state would have requested, or of course, it's not automatic, because the court has to consider factors such as safety of the community, which is a factor in the court's decision as to whether or not whether or not one that the interlock will be waived. That's a consideration. But I know the law talks about 50%, but the 50% is at the beginning when the court decides that they're going to order the interlock. It cannot be less than 50% of the supervision period.
Right, we're asking for a modification. And I believe you do have power to modify.
Yeah, the judge, the court has authority to modify, and I think that's 42A. IHIJKL 42A 751L gives the court the jurisdiction, retains jurisdiction of a hearing on subsection D to revoke, continue, or modify community supervision. And so the court has that authority. But
Yes, sir, the thing is it will create, you don't want to set a probationer up to fail. And by continuing this on there, she's going to fail because she will not be able to work in suitable employment as far as possible. Now, it's more important that she work in suitable employment as far as possible than to continue to have an interlock device in her car, which she's had no problems with for the last 9 months. And there also has to be some type of incentive for people to do everything they're supposed to do and be an ideal probationer, as Ms. Bertrand has been. There has to be some kind of carrot on the end of the stick, or else other people are going to fail and are going to continue to fail on probation. It's not going to be for the best interest of society. It's not going to be good for the community if she has to lose her job. It's not going to be good for her employer because they'll have to hire somebody else and retrain them again. So this would be very detrimental to the interest of society. It would discourage people from doing well on probation. It would get people fired. It would interfere with their employers. And who is your employer? What's the name of it?
CFI, Control Fluids.
And this is a big business, and she works for a key man in the company. And so it's important that to this company that they retain her. But you know what? They just can't let her go. They're trying to recover after the COVID epidemic. And they need all hands on deck.
okay, now
Even if she had another interlock device in her car, she'd have to take off half a day to get that done. And that would also have her employment blow up in effect. So she's trying to do everything right.
I understand. And just a note, when it comes to DWI cases, the code exclude DWI cases from even an early release.
That's another factor that
Right.
works in her favor because she cannot get off early based on good behavior. So the only thing the court can do to reward this is to ask that modifications be made to accommodate good probationers and encourage other people to be good probationers.
Yeah, but
Otherwise, I understand earlier today, there was some other people who maybe not necessarily were good probationers. I submit it's because maybe they didn't have the proper incentive. So we got to give these people
Well,
incentive to do well.
okay. But if you would have sat through the whole case, you would realize that there was like nine, various violation, but that's neither here nor there. The point is, the court is of the opinion that the community safety is of the utmost importance. And that is the reason for the interlock. Now, the court is taking judicial notice of the paperwork in the court's file. The court is aware of what's in the probable cause affidavit, what caused us to actually be in court and for Ms. Bertrand being placed on probation. In first place, I understand, Ms. Bertrand, that it is an inconvenience for you with regards to the malfunctions of the interlock. But the public safety is of the utmost importance here in this case, and the court at this point, at this time, is not going to grant the motion to give you an early release on the interlock. It will stay in place.
Thank you, Your Honor. May we be excused?
Yes,
Can I ask one question? How long will it be on the card? That
you can,
wasn't
you
in
can,
the paperwork.
your lawyer can answer that for you.
Must be on that break.
It's, oh, it didn't state, okay.
All right, thank you.
Okay.